Welcome to This Explainer. Today, we are diving straight into the Indian Partnership Act of 1932. If you've ever found yourself wondering how people legally join forces to build a business, well, you are in exactly the right place.
Think about it like this. Imagine you're a solo musician, right? And you've just booked a massive stadium tour. There is simply no way you can play the guitar, the drums, and sing lead vocals all at the exact same time. You need a band. Well, business works exactly the same way. What do you do when your solo venture completely outgrows your own two hands?
So, here is our game plan for today. We're going to start by looking at why partnerships even exist, then break down the actual legal definition, dig into the essential ingredients you absolutely need, and finally, wrap up with the four main types of partnerships. Let's get right into it.
Section 1. From Solo to Squad. Let's look at the natural evolution of a business.
You know, before legalized partnerships became a thing, people mostly operated as sole proprietorships, but they ran into a massive roadblock, a total lack of resources. When you're entirely on your own, your capital is strictly limited to your own bank account, and your skills are, well, just your own individual skills. You hit a ceiling pretty quickly. It makes it incredibly difficult to scale up and build a larger business all by yourself.
And that is exactly where the partnership comes in as the ultimate solution. By joining a literal band of partners, individuals can finally pool their capital and combine their diverse skills to launch much larger enterprises. Basically, a partnership is all about coming together to run a business way more efficiently for economic gain. It completely solves that frustrating resource scarcity problem that sole proprietors have to deal with.
Section 2. Defining a partnership. Now that we understand why these groups form, let's see how the law actually defines the squad.
Okay, so the absolute bedrock here is Section 4 of the Indian Partnership Act 1932. This gives us our exact, highly testable legal definition. It states that a partnership is the relationship between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. So it's not just a casual status, right? It's a very precise legal relationship born entirely out of an agreement. Just to quickly clear up the terminology the Act uses, the partners are the actual individuals who have entered into this relationship. The firm is the collective group, all those partners together. And the firm name? Well, that's just the name painted on the storefront sign. It's simply the name the business operates under.
Moving on to Section 3, the essential ingredients. That Section 4 definition is a pretty dense piece of legal text, so let's deconstruct it into its essential DNA. So what are the absolute prerequisites for a partnership to legally exist? First up, there has to be an agreement between the parties. And honestly, here's the wild detail. It doesn't even need to be in writing. It can be completely oral, express, or implied. Crazy, right? Second, there has to be an agreement to share the profits. Third, the business must be carried on by all or any of them acting for all. And fourth, there must be the existence of an agency between the people involved. If you are missing literally any of these ingredients, you do not have a partnership.
Now, while sharing profits is obviously a huge part of why you do this in the first place, the sources make a really interesting point. Just having profits isn't always the ultimate test of whether it's a partnership. The real glue holding the whole thing together is the mutual agency, that acting for all part. It means every single partner is an agent of the firm and an agent of the other partners for the business. That mutual agency is the true, definitive test of a partnership's existence.
Section 4. Types of partnerships. Let's see how all these ingredients can be baked into the different legal structures available out there.
We got four main types to cover. First, let's stack up general against limited partnerships. In India, traditionally, practically all partnership firms are general partnerships. Here, every partner takes an active role, but, and this is a big but, they face unlimited liability. That means if the business goes under and the firm's assets aren't enough to cover it, creditors can legally come after your personal property. Yikes! A limited partnership, on the other hand, caps that liability for some partners based on what they invested, protecting their personal assets. But the trade-off? They can't take an active role in management. Also, a limited partner leaving or passing away won't cause the dissolution of the firm. And just as a side note, limited partnerships are officially allowed in India now under the Limited Liability Partnership Act.
Oh, and there's one really important exception you need to know about for general partnerships: minors. A minor partner's liability is strictly capped at whatever their share is in the firm's capital and profits. So while the adult, active partners are out there risking their personal estates, a minor who's admitted to the partnership is completely protected from having their personal stuff attached for the firm's debts. Okay, next up, let's talk about duration.
Partnership at will versus a particular partnership. A partnership at will is exactly what it sounds like. There's no fixed time frame or specific purpose mentioned in the agreement. It goes on indefinitely and dissolves simply whenever a partner gives a written notice that they want out. A particular partnership is the exact opposite. It's formed for a very specific time period or to achieve one specified objective. Once that time is up or the objective is complete, boom, it dissolves automatically.
All right, if you're taking notes or studying for an exam, this is your ultimate cheat sheet. Just look at the contrasts here. General partners take on unlimited liability and take an active part in management. Limited partners cap their risk but give up that management control. And for duration, you've got the completely open-ended partnership at will compared to the strictly time-boxed particular partnership. It's all about balancing risk, control, and time frame. We're mapping out the actual lifespan of a firm. We'll trace its legal birth, its active life, and eventually, its legal death. By looking at this as a complete life cycle, these complex legal concepts are going to lock right into place for you.
Here's the roadmap for our explainer. We've got 4 main stops. First, the birth of a partnership, contract versus status. Second, its life, looking at the 7 different types of partners. Third, the pitfalls, zooming in on the infamous Jalal liability example. And finally, the death or dissolution of the firm. Let's get right into it.
Section 1. Birth of a partnership, specifically creation by contract.
So, how was a partnership actually born? Well, Section 5 of the Act lays it out plain and simple. It's all about the contract. A partnership is a purely voluntary, deliberate agreement. It doesn't just happen by accident. This makes it completely different from a company, or say a Hindu undivided family business, or a Burmese Buddhist husband and wife running a shop. In those family cases, the business relationship arises automatically from your status and inheritance. You're literally just born into it. But a true partnership, you absolutely need that deliberate, legally binding contract to kick things off.
All right, moving on to Section 2, the life of the firm and the 7 types of partners.
Once the firm is alive and kicking, who actually runs it? The law recognizes 7 distinct types of players. We've got the active partner, the sleeping partner, secret partner, limited partner, partner in profits only, nominal partner, and yep, even a minor can be admitted to the benefits of a partnership. Each one has a totally different relationship with the firm's management and, most importantly, its debts. Let's break them down.
Let's kick things off with the active partner, or as some call them, the working partner. This is your classic, full-fledged player. They put in the capital, they're managing the daily grind, taking their share of the profits, and everybody in the outside world knows who they are. But here's the catch. They carry unlimited personal liability for the firm's debts, meaning if the business goes under, creditors can absolutely come after this partner's personal bank account.
Contrast that with the sleeping or dormant partner. This person just brings the cash. They put in their capital, take their share of the profits or losses, but they never lift a finger to manage the place. And the outside world has no idea they even exist. But listen to this. Even though they're completely off the radar, their liability is still unlimited. If things go south, their personal wealth is just as much on the line as the active partners.
Then we have the secret partner. This one's kind of fascinating. Like the active partner, they bring in capital, share the profits and losses, have unlimited liability, and they're actually in there actively managing the firm. They do the real daily work. But, and it's a big but, their connection to the business is kept a total secret from the public. They're basically pulling the strings from the shadows.
Next up, let's compare 2 really specific roles. First, the limited partner. Their personal assets are totally safe. Their liability stops exactly at the amount of capital they put in, and the firm doesn't even dissolve if they face bankruptcy or lunacy. But they give up all management rights. On the flip side, we have the partner in profits only. They get all the upside, meaning the profits, but absolutely none of the losses. They usually just bring money and goodwill to the table, and they don't manage the firm either. But here's the kicker. They actually have unlimited liability when it comes to the firm's debts to outsiders.
And that brings us to the nominal partner, also known as the ostensible partner. Honestly, this is an incredibly dangerous position to be in. They don't invest a single dime of capital, they don't manage anything, and they take exactly 0 profits. All they do is lend their good name and reputation to the benefit of the firm. But by doing that, they suddenly become legally liable to outsiders for the firm's debts. All of the risk, literally none of the reward.
Which perfectly tees up Section 3, the pitfalls, featuring the famous Jalal liability example. Seriously, ask yourselves, what actually happens when a wealthy outsider just pretends to be part of a business? It might seem like a harmless favor, just helping a friend's company look a bit more legit. But under the Partnership Act, your words and the impressions you give can have devastating financial consequences. Let's walk through this classic case study. Step 1. We've got a rich guy named Jalal. He isn't actually a partner, but he straight up tells a supplier named Ramu that he's a partner in a firm called Alpha Enterprises. Step 2. Ramu is super impressed by Jalal's wealth, so he sells goods to Alpha Enterprises on credit entirely based on that trust. Step 3. Alpha Enterprises goes under and fails to pay Ramu for the goods. So, who takes the hit? Well, let's say those goods were worth 20,000 rupees. Because of his false representation, Jalal is now personally on the hook for that exact amount. He didn't run the business, he didn't take any profits, but because he gave Ramu the impression he was a partner, Ramu can legally recover that 20,000 rupees right out of Jalal's own pocket.
Now, how exactly does the law trap someone like Jalal? It comes down to two legal concepts. If Jalal actively spoke the lie himself, representing himself as a partner to Ramu, he becomes a partner by estoppel. He simply cannot avoid the consequences of his own words. But what if he just kept his mouth shut? Suppose Alpha Enterprises tells Ramu that Jalal is a partner, right in front of Jalal, and Jalal just stays silent and doesn't deny it. In that case, he's a partner by holding out. Whether it's an active lie or passive silence, the law holds you entirely liable to third parties who lent money based on that impression.
Finally, we arrive at Section 4, Death of a Firm or Dissolution. Just like it's born, a firm can legally die in a few different ways. It can happen peacefully by mutual agreement under Section 40. It could be compulsory under Section 41, like if everyone goes insolvent or the business suddenly becomes unlawful. It can happen because of certain contingencies under Section 42, like a fixed term expiring or someone passing away. If it's a partnership at will, a simple written notice under Section 43 does the trick. And lastly, it can be shut down by court order.
Speaking of court orders, under Section 44, a judge can literally step in and forcibly kill the firm. If a partner becomes of unsound mind, the court can dissolve it. If someone is persistently breaching management contracts and making it impossible to work together, the court can intervene. And crucially, if the business can only be carried on at a loss, the court will shut it down. The law doesn't expect partners to just bleed money forever. It gives them a legal exit strategy.
Have you ever wondered what actually happens behind closed doors when business partners, fundamentally disagree? It's honestly like the ultimate high-stakes student group project gone completely wrong. Except here, millions of dollars or literally years of blood, sweat, and tears are suddenly on the line.
Welcome to This Explainer. I am incredibly excited to be your guide today as we unpack the framework of the Indian Partnership Act 1932. Specifically, we're zooming in on the rights and liabilities of partners. We're going to explore the very real, strictly structured rules that dictate whether a business relationship survives, thrives, or just absolutely falls apart legally. Think of this as your personal rulebook to the real world of business.
So here's our agenda for today. We've got 1. Duties and rights. 2. Daily business conduct. 3. Restraint of trade. And then we'll jump into 2 absolutely critical case studies. The Natarash Theater case. And finally, evaluating negligence. Let's get right into it.
Starting off with Section 1, Duties and Rights. This is where we establish the absolute baseline expectations for anyone entering a business partnership. Before you can even start arguing about profits, you have to understand your basic legal duties.
Okay, let's dive into this. Section 9 of the Act lays down 4 absolute boundaries for general duties. First up, you've got to carry on the business to the greatest common advantage. Makes sense, right? Second, partners have to be just and faithful to each other. Third, you must render true accounts and full information on anything affecting the firm. But here is the massive one, guys. Every partner absolutely must indemnify the firm for any loss caused to it by their fraud in the conduct of the business. Basically, you commit fraud, you pay the firm back. Period. No exceptions.
Now, you might be wondering, how are those rights and duties actually pinned down under Section 11(1)? Well, it can be an expressed contract, meaning you sat down, wrote it all out, or explicitly stated it. But it can also be an implied contract. And this is fascinating because it means rights aren't always just ink on paper. They can legally be implied by a course of dealing. Essentially, how partners actually behave over time, like continually splitting costs in a very specific way without ever writing it down, can actually legally bind them to those unwritten rules. It's a real game changer.
Moving on to Section 2, Daily Business Conduct. Let's see how these foundational rules actually apply to the daily grind of running a business. So Section 12 outlines how partners handle the day-to-day operations. Unless you've made a contract saying otherwise,
every single partner has the right to take part in the conduct of the business. You get a seat at the operational table. In return, you're absolutely bound to diligently attend to your duties. You also get the absolute right to access, inspect, and copy any of the firm's books. And fascinatingly, this right survives even after death. If a partner passes away, their heirs or legal reps retain that absolute right to access and inspect those books. Pretty wild, right?
But what happens when partners just can't agree on a decision? Well, Section 12 provides a critical operational boundary here. Any difference coming up from ordinary, everyday matters connected with the business can just be decided by a majority of the partners. But, and this is a big but, if you want to change the actual nature of the business, that requires the explicit consent of all the partners. Unanimity is an absolute must to shift that core vision.
All right, Section 3, Restraint of Trade. Setting boundaries. Now, what if a partner starts a side hustle? Can you legally stop them from competing against you?
Notice how these specific legal sections map directly to do not compete scenarios. It's like a giant puzzle. Under Section 11.2, contracts can completely restrict an active partner from carrying on any other business. If a partner is outgoing under Section 36.2, or if the firm is dissolving under Section 54, or even if we're talking about the sale of goodwill under Section 55.3, partners can totally agree not to carry on a similar business within specified local limits or time periods. The really key legal caveat here, though, is that these agreements are only legally valid if the restrictions imposed are actually deemed reasonable. You can't just ban someone from working forever.
Section 4. Case Study on the Nataraj Theater. The Right to Participate. It's time to step out of the textbook and into the courtroom to see how these theories actually hold up when the gloves come off.
The scene is the Nataraj Theater case in Navsari. Just imagine this. You're a co-owner of a movie theater only for your own partners to literally physically lock you out of the manager's office. The context here revolves around Section 12, which we just covered, a partner's fundamental right to participate in the conduct of the business. So the huge question posed to the judiciary was essentially this: can a court actually step in and stop a legal partner from doing their job and running the firm?
The ruling was absolutely definitive. The court stated, this right cannot be fettered by any court unless there is a contract to the contrary arrived at amongst the partners themselves. In other words, those Section 12 rights are supreme. The court is not going to step in and just strip a partner of their management rights unless the partners had mutually, explicitly agreed to that limitation in their own contract beforehand. So the crucial takeaway here is that while the partner has these deeply protected rights, they cannot just hand those management rights over to a total outsider. As established in this context, under Section 29 of the Act, a transferee, which is basically someone who acquires a partner's financial interest, has absolutely zero right to interfere in the conduct of the business. Think of it like this. You can absolutely sell your share of the profits, for sure, but you literally cannot sell your seat at the management table.
Section 5. Case Study on Evaluating Negligence. Let's kick off our final section by asking a highly sensitive, somewhat awkward question. What if a partner makes a truly terrible business decision that loses the firm money? Are they legally liable just for being bad at their job?
Well, this brings us to the historic case of Sasti Kinker versus Gobinda. Imagine a partner makes a completely disastrous investment that completely tanks the company's funds. The core conflict here was trying to figure out the exact legal standard for a partner's liability when they are explicitly accused of negligence in running the firm. And this sets the stage for a surprisingly subjective legal ruling.
When we look at negligence in the context of business conduct, the ruling gives us this mind-blowing definition. A partner is not liable for negligence if they can demonstrate they used the specific level of skill and intelligence that they actually possessed. I mean, let that sink in for a second. The law absolutely does not expect you to be a flawless business genius. It just expects you to try your absolute personal best with the actual mental tools you have.
And the final verdict of the court was crystal clear. A partner is not liable for negligence if he can show that he used such skill and intelligence as he possessed in the conduct of the business. It absolutely proves that business liability in this specific context is based on a totally subjective capability test, not just an objective measure of failure. Basically, if you gave it your all, even if your all really wasn't very good, you aren't legally negligent.